Welcome to Real Talk, Family Law with Richard Lebovitz.
Hey everybody, welcome back to an all-new episode of Real Talk, Family Law with Richard Lebovitz. I'm your host, Mike Leon. Richard here is a seasoned Maryland family law attorney with decades of experience guiding clients through divorce, custody disputes, and other family matters. And he's known for his straightforward answers and commitment to helping families move forward with confidence. And in today's episode, we're going to be talking about how Maryland courts decide child custody. Richard, good to see you. As always, let's talk about this at a high level first. So when parents come to you, they've got custody concerns. What's the first thing they usually want to know about the court's decision process?
Sure. Well, again, thank you for having me on your show today, Mike. It's a pleasure. So when dealing with courts, one of the first things I try to do is explain the process to the prospective client so they understand essentially what to expect. Because having been practicing law for over 33 years, I know from experience, I know essentially what the courts may or may not do based on different fact patterns for different cases. Most clients would not understand that it's a slow process. So by the time, from just meeting with somebody and we're starting a case from scratch, obviously I need to find out, one, will the parties be amendable to a consent order or negotiating in good faith to resolve things amicably, or is this could be a hotly contested custody matter? So explaining to the courts, to them what the courts may do. The problem is it could be up to a year before there's a hearing. So is in the vacuum, is this something that we can negotiate an agreement ourselves, or is there counsel on the other side that we can set up a four-way meeting to try and resolve issues? And I can definitely give the clients bullet points and talking points and forms to fill out so that we have a better understanding of what the actual issues are, so we can try and figure out a way to reach a agreement.
Richard, I think people have this misconception about some of these decisions. The custody decisions specifically are automatic. The mother is always going to get primary custody. Can you explain if that is a misconception and why it is?
Sure. Yes, I constantly, there's all these different camps out there would have you believe that the courts favor the mother, that there's a whole movement for fathers' rights. There's lots of firms out there to advertise for fathers' rights. I would say it's really all a myth. That again, every case is fact specific. For every time that there is a mother who believes that that she's in charge and the father feels that the mother's in charge and the courts are biased in favor of mothers, there are cases where the father basically gets all the rights and the mother is the one fighting to get back in it really depends on the underlying factors. Was mother or father, addicted to drugs or alcohol? Or was the one or the other parent not really active in the child's life? Or is it more of focused on, say, child support or decision-making issues or basically or parental alienation? There's lots of issues out there that are underlying factors that the courts would look at. So while again, depending on the issues presented to me by the client. If the client says, hey, I haven't seen my child in 6 months or in a year and I'm fighting to get custody, then yes, they would have this perception that usually if that was the male client, then they would feel that the court may be biased against them. But I would say that the court, if anything, would have them maybe jump through some hoops and then do some therapy or some classes or parenting classes and learn how to co-parent and build them up to get to some kind of access schedule that fits within their work schedule. So there are ways to break this mold and get them the access and custody that they deserve and ultimately is in the best interest of the child.
Richard, you mentioned underlying factors. Let's talk about some of the legal factors that Maryland judges, what are they required to consider when they're deciding custody from a legal perspective?
Sure. So in even recent case law that there's basically the courts are all based on past case law. And there's new legislation essentially that the judges need to enumerate different factors for custody when determining whether it's a joint custody case or primary physical custody case or relocation cases. Some of the factors would include, say, the fitness of the parents, Are both parents fit and proper people to have custody of the child? Are they both sober? Are they free of drugs? Are they both are they employed? Do they have the ability to care for the child? Do they have a proper living arrangement whereby maybe they're are they couch surfing with different people's houses or in a hotel, or they actually have an apartment or a house with a suitable separate bedroom for the child or a place for the child to stay? The cleanliness of the unit. Is there say other family members in the area that can help with the child? The age and the age of the children, the age and preference of the children, other siblings. Just say there's lots of different factors that go into play. Possibly the social economic factors of are the parents even able to support the child or raise the child? So they're all, and no one factor has more weight than the other. So there are lots of different things. Or they say the sincerity of the parties. Are they just asking because they just figure if the other party has custody, that therefore they should have it? Or is it really? Are they really thinking of the best interest of the child or of their own self-interest? So there are lots of factors that go into this, and the court or the judges and magistrates who hear these cases are basically listening for some testimony on some of these different factors to weigh and figure out an order that would work for everybody.
You just mentioned best interest there. So let's talk about a child's best interest and this phrase. What does it really mean in practice? Can you share some examples of how you've seen the court apply that specific standard?
Sure. So the best interest of the child is really paramount, the main issue for all custody cases. And it sounds like this daunting idea, the best interest of the child. Like I said, what does that mean? That is where essentially the child, of course, being too young to really speak up for themselves. So a professional, based on, say, child development or things of that nature, needs to decide what really do they believe is in the best interest. So obviously, it's best that there's two parents available to have both parents be involved in that child's life. So we would essentially need to figure out, if say you may have one parent who just for whatever selfish reason maybe broke up with the other party, or the other party started dating somebody else, so they're withholding the child out of spite. Well, that's not in the best interest of the child. That's just someone's self-interest interfering with the access of with the child. So those are the issues that really come up. It's all about perceptions, right? So if I have the party who's being denied access, I can say, well, we can fight to get in the court and eventually get you the access you deserve. And for every day or month that you're being denied access, the court's essentially going to penalize the other party for doing that. But again, it's really thinking in a perfect world of where the child has equal access to both parties. If they're based on child or accepted child development issues of, say, an infant to say they're 3 years old, to see both parties as frequently as possible, as opposed to if they're a little bit older, where a week on, week off custody schedule may be perfect for shared as a child's a little bit older, but that doesn't really work if they're under 1 year old or a toddler. They need to have some stability, and they need to know both parents are active in their lives. So again, it's based on child development issues, and really then what in play comes down to the parties and their say employment. Are the parties employed, not employed? Do they have work schedules? Say is a client going to work working the night shift? Are they going to work at 4:30 in the morning, where the child would have to get up at 3:30 to be dropped off, some crazy hour? Or are they, the proximity of the parties to each other? Is the child going to be in a car for an hour and a half each morning or each way to and from school or daycare? So those are all issues that go into the best interest of the child.
Does the child then ever get to decide where they want to live? How much weight does the court give to a child's preference? I'm assuming it's based on the age of the child sometimes.
Yes. So it really depends. It's all based on the age. So in a perfect world where money was no object, the court could appoint an attorney. Here in Maryland, we would call that a best interest attorney, where the best interest attorney essentially can way can speak to all the parties that the parents want them to talk to, and essentially be the attorney for that child. But technically, you would say, working backward, obviously an 18-year-old is an adult. A 17-year-old would basically be almost an adult, so they can definitely be interviewed by a judge to say what their preferences are. And the courts may pretty much, say even a 15-year-old can probably say what they would like. But when you're that sweet spot, like between 11 and say 14, the child's really too young to be, to really make a decision. But some judges or magistrates may, based on their own personal preference, may interview the children, and they usually do it what's called in camera, where they would take the child into the hallway, outside of any earshot of either of the parents or in their chambers, and maybe ask a few simple questions like, you understand right from wrong, and ask some basic questions about preference, or get to know the child briefly. And then after they do that interview, then they would then tell the parties, later on, a quick summary of what was discussed. So some judges will in fact listen to some of the preferences of the child, but normally we understand that children tend to want to please whatever parent that they're with, and again, that's where the judges tend to weigh those the pros and cons of actually interviewing the child. But yes, the judges do from time to time interview children to get an understanding of their preferences, and it really depends on really how highly contested the case is.
Richard, what about the parent's ability to cooperate during these proceedings? Does the court weigh that in the custody arrangements? Is that a mistake you sometimes see parents often make, the cooperation angle?
Yes, it really just comes down to the ability for co-parenting. So here in Maryland, every jurisdiction, when you would file a complaint for custody at a scheduling conference, the courts always want the parties to take a 6-hour co-parenting class. Essentially, is over two different nights. It used to be going to the courthouse and then taking these classes. Now it's all online. But essentially, you need a file your certificate of completion of that course. It's not how to parent; it's how to co-parent. And then co-parenting really leads into this whole aspect of decision making and legal custody, where you're making decisions. How easy are the parties able to co-parent and work together? They may disagree on access, but if the child needs braces or medical issues, or what school the child goes to, or major legal issues, then if they are able to co-parent and work together on that, that's a huge factor in deciding custody.
For parents right now that they're listening to this, maybe they're worried about losing time with their child. What steps would you advise them right now that they can take to kind of strengthen their position?
I would strongly advise them to essentially keep a journal, essentially on a day-to-day basis of either what type of access do they have now, how often are they reaching out to the other party who essentially is the gatekeeper preventing them from having access, and or document all communication from between the parties. That's one tool to keep in mind. Maybe have a shared calendar to have an understanding of what the activities are. Are they actually communicating these issues, or is one parent essentially dominating or refusing to give the other party the access to the information? Is there a doctor's appointment? Is there a dentist appointment? Is there a parent-teacher conference? As much as it would be a perfect world, it would be great for one party to just let you know, but they don't always do that. So then the other party should be able to confirm what school the child goes to, contact that school, say, hey, I'm the other parent, and put me on the contact list, and get involved in the school, and basically you circumvent the other parent and find out what's going on. So there are many ways to work with the parties, depending on what the circumstances are, to help them bolster their case going forward.
And Richard, finally, as we land the plane on this episode, what's your message to a parent right now who's maybe anxious about these custody proceedings, but they want to do what's in the best interest of their child? What's a piece of advice you would give to them?
Well, a piece of advice that I give to people is essentially, again, document things, but stay the course. Doing anything drastic, while it may, as a knee-jerk reaction, seem like the right thing to do, it usually comes back to haunt them later. So I would say, play nice, try and get along, with the other party, and maybe talk to me or other attorney, figure out essentially a plan or a strategy of essentially how to get to the access that they believe is in the child's best interest that specifically includes them. So the old idea of a snatch and grab, it's easy to say essentially both parties have a clean slate. They have equal access to the child, but if one parent is essentially the gatekeeper preventing the other one party from having the child, you might say, hey, I should just go pick up the child from daycare or from school and have the child with me. But that doesn't necessarily work. That may make you feel great that you got the child that one day. You know darn well that the other parent's going to immediately object to that, and you're going to eventually have to give the child back. So to me, it's keep the peace. Let's try and negotiate some kind of access schedule. It may be less than what you think you're entitled to now, but it goes a long way to building the trust moving forward. And to me, that I think that's really a prime example of don't be so contentious. Let's do our best to work together. And again, baby steps. Maybe I can't get everything I want today, but if the grand goal is 6 months or a year from now, I'll finally have what I want. Let's try and work out a path towards that.
Yeah. Richard, thank you for the time and insights on this important topic, man. We truly appreciate it as always.
Well, thank you again for having me on your show. It's been a pleasure, and I look forward to the next time.
And thank you to everybody out there listening to another installment of Real Talk Family Law with Richard Lebovitz. If you're going through a custody dispute right now, or you just want to understand your rights as a parent, Richard's here to help provide those clear answers and guidance. Do me a favor, visit LebowitzFamilyLaw.com to learn more or schedule a consultation with Richard and the team. And as always, like, subscribe, leave a review or comment, or share this episode with somebody who needs to hear it. As always, I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.